Well-known rapper Young Thug, whose real name is Jeffrey Williams, was indicted on May 9, 2022 in Fulton County, Georgia under the state's anti-racketeering law, with a re-indictment being filed on August 8, 2022. Prosecutors accused Mr. Williams of leading a criminal street gang known as YSL, or Young Slime Life, alleging that it was connected to his hip-hop record label Young Stoner Life, and brought charges including conspiracy and participation in criminal street gang activity, along with various gun and drug charges. The case was scheduled for a jury trial, and on Friday, June 7, 2024, Fulton County Superior Court Chief Judge Earl Glanville, who was presiding over the trial, found one of the state's witnesses in contempt for invoking the Fifth Amendment and refusing to testify despite being granted immunity. Judge Glanville then ordered the witness to be jailed until Monday, June 10, 2024, when the court would revisit the issue of his willingness to testify. On the morning of June 10th, Judge Glanville met in his chambers with Prosecutor Adrian Love, the witness, and the witness's attorney. The meeting was transcribed by a court reporter, and by the end of it, the witness agreed to testify. The defense attorneys for Mr. Williams and his co-defendants were not present for the meeting, nor were they informed that it was occurring. For this reason, the meeting would qualify as a so-called ex parte communication, which is defined as communication between a judge and one party or that party's lawyer without the other side being present. Under Rule 2.9 of the Georgia Code of Judicial Conduct, judges are prohibited from initiating, permitting, or considering ex parte communications concerning a pending or impending matter, with limited exceptions. After learning of the ex parte meeting from an undisclosed source, one of Mr. Williams' defense attorneys, Brian Steele, raised the matter on the record before Judge Glanville in open court.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel, met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No.
else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation. Look how you got this information, and you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you what,
I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I am not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements.
Judge Glanville asks Mr. Steele to tell him how he learned about the ex parte meeting, and Mr. Steele refuses to comply, citing attorney-client privilege. Judge Glanville then orders a 5-minute recess and informs Mr. Steele that if he does not provide the source of his information when they return, he will hold him in contempt. According to Rule 1.6 of the Georgia Rules of Professional Conduct, attorneys are required to maintain in confidence all information gained in the professional relationship with a client. The comments to this rule clarify that the requirement applies not only to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. However, Rule 1.6 does include a caveat that attorneys may disclose information as required by a court order. After the recess, Judge Glanville resumed the proceedings and called Mr. Steele to the podium.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well,
you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is
he should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're saying, you're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Mr. Steele once again refuses to share how he learned of the ex parte meeting, and Judge Glanville holds him in contempt, giving him until 5 p.m. to divulge his source. In support of his position, Judge Glanville argued that he was not asking Mr. Steele to share confidential information, but rather that he was only asking him to explain how he obtained that information. Mr. Steele disagreed, taking the stance that even disclosing his source would be a violation of his ethical obligation under Rule 1.6 to keep all information gained in a relationship with a client confidential.
Judge, listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you 2 things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside our presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, why can't we have an issue that was outside of presence? It should not have been.
because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
Why
that's
did
for
we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that the one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says.
Mr. Steele moves for a mistrial based on Judge Glanville's ex parte communication with a witness. A mistrial occurs when a trial is ended before a verdict is reached because some event has made it impossible for the proceedings to continue in a fair manner. In such instances, the case may be retried before a new jury, unless double jeopardy or another legal prohibition prevents it. As the Supreme Court of Georgia explained in the 2016 case of Scudder versus Georgia, criminal defendants generally have the right to be present at all quote-unquote critical parts of their trials. However, this right can be relinquished if the defendant or defense counsel waives it. In the Scudder case, a criminal defendant argued that it was an error for a judge to meet privately in his chambers with a witness, but the court concluded that he had waived his right to be present because the judge announced his intention to speak privately with the witness in open court, and neither the defendant nor his counsel objected. Now, because Judge Glanville's ex parte meeting with the witness was conducted secretly without the criminal defendants being informed or even given the opportunity to attend or waive their right to be present, Mr. Steele and other defense counsel have a strong argument that the meeting in Judge Glanville's chambers violated the criminal defendant's right to be present at all critical parts of their trials.
And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there. Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, Paragraph 4.
You already said that. You've already said
Georgia
that.
Constitution, and we had a right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did that particular issue so much as it was to try and assert an inaccurate, what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Ms. Love contends that the defense did not have a right to be present at the ex parte meeting because it involved the civil contempt order imposed on the witness. Civil contempt proceedings are technically separate from the underlying criminal trial. For this reason, it is arguable that Judge Glanville could address the contempt matter directly with the witness and his attorney without the criminal defendants or their counsel present, since their liberty was not at stake in that moment. However, even if the contempt order was technically a civil matter between the witness and the court, the ex parte meeting directly affected the criminal trial because it resulted in the witness agreeing to testify for the state. As we discussed earlier in this episode, judges are prohibited from engaging in ex parte communications on substantive issues in a pending case. Accordingly, there is substantial merit to the argument made by Mr. Steele that the defendant's rights had been violated during the ex parte meeting, even though it was technically a discussion regarding the civil contempt order against the witness. After denying multiple motions for mistrials from the other criminal defendants' attorneys, Judge Glanville returns his focus to Mr. Steele.
Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody, and once he clears the area, we'll go ahead and get started.
If by that point means that we'll get started with doing the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and without
You don't have that luxury at this point in time, sir. You don't.
without the court addressing.
You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot. And
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only. Okay, well then you've made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you made your... No, we're not doing that at this point in time. So you'll have a choice to make. All right. Take Mr. Steele into custody, please. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir.
After Mr. Steele refused to disclose how he had learned of the ex parte meeting, Judge Glanville held him in criminal contempt and ordered deputies to take him into custody, briefly removing him from the courtroom in the middle of the trial. Later that day, however, Judge Glanville allowed Mr. Steele to return so that the proceedings could continue, explaining that he did not want to deprive Mr. Williams of his chosen counsel. Instead, Judge Glanville sentenced Mr. Steele to 20 days in jail to be served on weekends so he could continue representing his client during the week. In an unusual request, Mr. Steele asked to serve his time in the same facility where Mr. Williams was being held so that they could continue working on the case together. However, after Mr. Steele was sentenced, he immediately sought appellate relief. The Georgia Supreme Court granted an emergency stay, which paused enforcement of the sentence while the issue was reviewed. Then, in October of 2024, the court reversed the contempt order altogether, holding that Judge Glanville should have recused himself from presiding over the contempt matter since he was personally involved in the dispute. Accordingly, Mr. Steele was never actually required to serve any of the time that he was sentenced to. Additionally, on July 15, 2024, Fulton County Judge Rachel Krause removed Judge Glanville from the case in response to recusal motions submitted by counsel for the criminal defendants, and Judge Paige Reese Whitaker was then assigned to preside over the trial going forward. On October 31, 2024, Mr. Williams pled guilty to 1 gang charge, 3 drug charges, and 2 firearm charges, and entered a no contest plea to another gang charge and a racketeering conspiracy charge. He was sentenced to 40 years, with most of the sentence suspended. His initial 5-year prison term was commuted to time served, and he was placed on 15 years of probation. Under the terms of his sentence, if Mr. Williams violates the requirements of probation, he could face up to 20 years in prison. This proceeding highlights a fundamental tension in the legal system, the balance between judicial authority and the ethical duties of defense counsel. Judge Glanville asserted his power to demand answers in order to maintain control over the proceedings, while Mr. Steele resisted on the ground that his obligations under the rules of professional conduct required him to safeguard confidential information related to his client. The clash also underscores why ex parte proceedings are prohibited except in narrow circumstances. Such meetings, even if nothing improper occurs, create the appearance that a judge may be influenced by one side, or that one party may gain an advantage outside the adversarial process. By forbidding these communications, the rules seek to preserve public confidence in the judiciary's impartiality. Together, the events in this case illustrate how the legal system must constantly balance judicial authority, attorney ethics, and safeguards designed to ensure both fairness and the appearance of fairness. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society.